This month, the Wisconsin Court of Appeals decided a family law case. It's not recommended for publication, but it's an authored opinion, so that it can be cited for its persuasive, although not precedential value. It's interesting for a couple reasons. Number one, it is the first case by the Wisconsin Court of Appeals in family law that is either recommended for publication or an authored opinion since September. That is 3 months without any authored opinions. And I do a family law update program for the Academy of Matrimonial Lawyers, and do it for the Wisconsin Family Court judges. And apparently I'm not going to need as much time for that program in 2017. There just aren't that many cases coming down. The actual case itself isn't all that interesting, but there are a couple of aspects to it that I do want to talk about. The case is called Rose versus Rose, and if you read the January 2017 flu, we'll have a short summary of it. What the case deals with about is a custody and placement agreement where the parties agreed to use a referee to make decisions if they can't agree. And the Court of Appeals affirms the trial court in upholding the agreement and finding that it did not violate public policy. I have no problem with the decision, although it very much appears to contradict other Wisconsin cases which say that parties cannot stipulate to freeze child support at the high end. They can apparently agree on the low end, but not on the high end for increases, because that would violate the public policy of Wisconsin. I've criticized those decisions in various articles. I think it's a wrong decision. I think it's interesting in Rose that they completely ignore it and deal with it simply as a custody and placement issue. One would think if you can't stipulate regarding child support because it affects children, and children aren't parties to a divorce action, the same thing would apply to custody and placement. But what do I know? The other thing that's interesting about the case, however, is that there is a prior case which they don't even bother to cite. That case is called Lawrence, Lawrence. It's 276 with second 403. Far be it from me to criticize the research ability of the Wisconsin Court of Appeals, but come on now, you got to cite it. The case is pretty much exactly on point in that it deals with the parties agreeing to a special master, which is the same thing as a referee. And in Lawrence, they actually do the research into what the prior case law has been in terms of stipulations and reviewability. They reach sort of an odd decision in Lawrence. What they say is that the agreement is effective and not against public policy because the agreement to use a special master or referee can be reviewed by the court. The ultimate decision is not reviewable by the court. In other words, once the referee or special master makes a decision, there's no recourse in court, which I think is odd. But the agreement to use the special master or referee is reviewable based upon a substantial change in circumstances. So I think the reasoning in Lawrence is strange. If anything, the decision of the special master and referee ought to be subject to judicial review. And as I said in Rose, it's odd that they don't even cite Lawrence. And for some reason, the only thing I can figure is they didn't do the research and couldn't find the case. But the other reason I wanted to mention all of this is because, well, it's not an everyday occurrence to have special masters and referees. It does happen. It happens under a couple of different circumstances. A very common one is we're negotiating as lawyers a custody and placement agreement. The parties are having a disagreement and nobody wants to go back to court. It's expensive. It's inefficient. The rules of evidence don't seem to acquit themselves well in terms of being able to get the information in front of a judge. In order to settle the case, it's not uncommon to have the parties stipulate that either the guardian ad litem or a therapist can be the, quote, tiebreaker, or ultimately make the decision in the case one way or the other if there's an impasse between the parties. It's not uncommon parties will do that. And it happens on occasion, again, not real commonly, but if there's a disagreement more commonly on financial issues that are unusual or difficult, that some courts, and I practice quite a bit in Waukesha County, and I've seen a number of cases where they've appointed a special master referee to help them. I've actually been appointed in that role myself, and again, subject to judicial review, it seems to be perfectly appropriate. But there is a case out there that you ought to be aware of. It is a non-family law case. It's called Universal Processing Services versus Circuit Court of Milwaukee. The citation on it is 2016 AP 923. The case involves a lawsuit regarding a credit card company, and remember the details, not important for our purposes today. And it goes to court, and there's apparently quite a battle over discovery. And the circuit court judge, who was a Milwaukee Judge John D'Amato, decides that a referee or special master would be helpful in dealing with these discovery issues. The reason I mention Judge D'Amato by name is he's one of the hardest working judges I've ever been in front of. He's and a very decisive judge. I've never seen Judge D'Amato have a problem making up his mind on anything. So my guess is if a judge like John D'Amato felt that a special master referee was necessary, it wasn't because he's trying to slough off the work. It's because the demands in terms of the discovery issues were so extensive and so great that he felt that additional services were needed. And he appoints Reserve Milwaukee County Circuit Judge Mike Skorowski as the referee. It appears that discovery went on for a period of time, but one of the parties wasn't real happy with it, and they've challenged the court's authority to appoint a special master or referee. The status of that case is that it bypassed the Court of Appeals. Actually, I believe it was filed as a direct action in front of the Supreme Court. And that's how it bypassed the Court of Appeals. In any event, in early November, there were oral arguments in front of the court with the Attorney General representing the Circuit Court, Judge D'Amato, in it. And it's got nothing to do over the holiday weekend or sometime. It's an interesting argument before the Wisconsin Supreme Court. A few interesting things about the decision. As I said, number one, I thought it was interesting that a judge like John D'Amato thought a special referee or special master referee was necessary. Second, maybe it's an aside, I don't know, but he ordered Judge Skorowski's compensation to be $450 an hour. Now, that's really top rate for lawyers in Milwaukee. I don't know a whole lot of lawyers that charge that much, and I don't think I know any that charges more than that. But remember, this isn't a practicing lawyer. This is a reserve judge, which means that if you say a lawyer is going to get paid $450 an hour, they're lucky if they see 50% of it, more like they're going to see 40% of it. We have this thing called overhead before we can put any money in our pocket. And Judge Skorowski, to the best of my knowledge, doesn't have rent to pay for a law office, doesn't have a secretary to pay. Pretty much it's dollar to dollar. So it's sort of the equivalent of ordering payment of $900 an hour for his time and services. I don't know if it was accidental, and knowing Judge D'Amato, I sort of doubted, but I just thought it was an interesting aspect of the case. I think it's also sort of interesting that the Supreme Court accepted it as a direct appeal. Now, it's possible they could punt it down later after oral arguments. It's unlikely, but anything's possible. I think it's interesting that the case had gone through a certain number of arguments about discovery already, and appears somebody didn't like the decisions. No kidding, and that's, of course, why they started the action in front of the Supreme Court. In any event, it presents, aside from the issues that I just discussed, a very central question to our system of laws that would affect these family law cases where the court either approves a stipulation for a special master referee or the court does it on its own motion, which is our system is based upon the decision makers being elected officials, maybe initially appointed by the governor if there's a vacancy, but eventually approved by the voters, whereas a special master or referee is someone who is just appointed by the judge. And it presents the interesting theoretical question of to what extent is use of special master referee something that violates our entire concept of an elected judiciary. Not that I'm saying elected judiciary is particularly good or bad, I'm just saying it presents the question. So if you're interested in that issue, I really would suggest you take a look at the briefs in the case. They're extremely well written. These are very good lawyers, and listen to the oral arguments. They're really interesting. Far be it from me to tell the Supreme Court what to do, but oh, what the hell. Here's what I think they're going to do and what I think they should do, which is in the right case, it really does help to have a special master or referee who can make quick decisions, who know the people, know the parties, and especially in the area of law that I practice in family law, that can do it in more of an informal sense. You don't have to schedule a date and have someone take the witness stand and have rules of evidence apply, but you can do it in a more informal sense, get all the information you need. Certainly if the parties agree to do that. If mom and dad say, hey, we're having problems and may have trouble figuring out which school our child should go to when the child's at school age. And that's really the most common issue where joint custody comes into play. Obviously, our child can't attend two different schools, 1 week at one week at the other. Someone's got to make this decision. Courts are expensive. Right now, it can take 90 days to get a hearing date before the Milwaukee Family Court Commissioner. I'm not making that up. And that's a lot of time. So if there's somebody we both trust, be it a guardian ad litem or a therapist, I don't see a problem with the parties being able to reach that agreement and the court approving it, although I do think judicial review always ought to be available at the back end. In terms of the court doing it on its own motion, I think it depends on the circumstances, and like a lot of other things in this field, cases vary so dramatically from one to another. I think it would be a mistake to make a blanket rule that's going to cover all eventualities. The nice thing about family law is the maxim one-size-fits-all does not apply. We deal with lots of different variations, a lot of different sizes, and we have to stay flexible. So I think what the court should do, but I think they will do, is say that courts can approve those agreements, and in the case of universal processing service where there's no agreement between the parties, that if the court makes appropriate findings as to the reason that a special master or referee would be helpful in an individual case, that it's within the court's discretion to do so. The case was argued, as I said, early November. Given our Supreme Court, February, March, April, something like that, they should be reaching a decision. Stay tuned. I will run a summary of the decision in flu when it comes down.